NBC 10 at Issue starts now.
In towns across Pennsylvania, gun control laws are coming off the books.
This is a matter of public safety. It was just another law that was probably unenforceable.
We'll look at why local leaders are repealing laws that they support and what the changes mean for gun owners. The convention is coming to town. Democrats choose Philadelphia. We'll look at what it means for the local economy. Plus, on this President's Weekend, a look at Abraham Lincoln's legacy with new insights from a local author and a unique approach to helping Philadelphia schools, and this one has a proven track record.
Good morning, I'm Renee Chanel-Fatah. Welcome to NBC 10 at Issue. People are allowed to carry guns into public buildings, even local parks, all because of a new Pennsylvania law that's prompting local municipalities to repeal their gun control measures. Allentown is one of the most recent cities to do so. In early February, city leaders in Allentown reversed portions of their ban on guns in public places. The reason? They're trying not to get sued. It's now legal in Allentown to carry guns into city buildings, city meetings, even into public parks. City officials tell NBC 10 they felt backed into a corner, forced to repeal the very laws they support in order to avoid an expensive lawsuit from groups like the NRA that have threatened to file suit against many cities in the state, and most of them are caving to the pressure by repealing gun laws.
Literally, people would be able to attend city council meetings packing heat. And I think that's a terrible idea.
A few cities are not backing down. Philadelphia and Pittsburgh have vowed to fight the NRA in court. Allentown Mayor Ed Pawlowski gave a statement to the city council in early February. He says, in part, "I cannot put the city at risk of heavy financial loss with potential lawsuits." He goes on to say, if court challenges are successful, I will be the first to reintroduce our ordinances for council's consideration and support. Many smaller municipalities in our area have already repealed their laws. Dozens of towns have changed their gun laws since Act 192 was passed. Now, this map shows some of the more than 20 towns just in our viewing area that have amended or repealed their ordinances or are in the process of repealing them. Since Act 192 went into effect in early January, dozens of Pennsylvania towns and municipalities have repealed their gun laws. So, here to discuss this issue in depth are attorneys on both sides of the debate. Joshua Prince is an attorney who specializes in firearms laws. He has sent letters to nearly 100 municipalities on behalf of several groups that advocate for gun rights. And Sheira Goodman is the executive director of CeaseFirePA, Pennsylvania, a nonprofit organization that works to reduce gun violence. I'm going to welcome both of you, and I know you both have talked about this issue together, so I think we're in for a really engaging discussion today. Let me ask you first, Mr. Prince, why was Act 192 necessary?
It was necessary because a number of municipalities were enacting ordinances in violation of the state preemption that already existed since 1974. And a number of individuals were being prosecuted. In fact, as recent as a year and a half ago, 8 individuals up in Erie, Pennsylvania, were prosecuted under an unlawful ordinance that prohibited the carrying of firearms in city parks. Those individuals would later be exonerated because the ordinance was unlawful, but they had no ability to obtain payment for all the attorney fees that they incurred.
And certainly attorney's fees, that's a big issue, a big part of Act 192. But before we go further, I'd like you to respond to what Mr. Prince has said, Ms. Goodman.
So Josh is right that he had this case a year and a half ago of these gentlemen who wanted to take guns in a park and were prosecuted, and they successfully sued and won. Act 192 doesn't really deal with that. What Act 192 says is you can now sue any town that has an ordinance that you don't like. You don't have to live there. You don't have to have any plans to go there. You don't have to be a gun owner, and the ordinance didn't have to be affected against you. So you can sue, or you can get some organization to sue.
So in other words, this whole issue of standing,
correct,
really, which means that you have a connection or a relationship, a significant one,
well, you have
to be a plaintiff
to sue traditionally in American courts, in Pennsylvania as well. You have to be harmed or be in imminent danger of being harmed. That has been removed. Act 192 completely changes the definition of what it means to be an aggrieved person for the purposes of constitutional standing.
And I imagine you would dispute that.
Yes,
Mr. Prince.
because again, an individual should not need to be prosecuted criminally in order to get an illegal and unlawful law invalidated. That is why the General Assembly went forward and invalidated these ordinances by providing the civil mechanism for which people and membership organizations could challenge it.
But traditionally, hasn't it been that you do have to be the person that's aggrieved? Otherwise, almost anyone could come into the court for any reason. That's why you have standing.
Yes, traditionally. However, we do have some case law here in the Commonwealth, again, where they've said an individual does not need to be prosecuted criminally in order to obtain standing to challenge a law.
But here, they've completely changed that, and I don't really believe, I disagree with Josh. I don't think that's why this act was passed, to help the few gun owners who may have been aggrieved. I think it was
Why do you
passed
think it was passed?
because the NRA and other groups like Josh's wanted a gift. They wanted to be able to get into court. They had been denied standing to challenge certain ordinances like lost and stolen reporting. If your gun goes missing, you report it. The Supreme Court said you don't have standing to challenge this. They wanted to change that, and in addition, they got attorney's fees. If the state really was concerned that municipalities were doing something wrong, there were other ways to do this. They could have talked to the district attorneys, they could have talked to the attorney general, and until, for the last 40 years, we had Republican attorney generals, including one who then became governor. They could also have just said, you have standing to have a declaratory judgment. What they've done is created a special right that exists for no other kind of law and lopsided penalties. So Josh, if successful, will get attorney's fees.
Political, and you would respond.
I completely disagree. We see this very frequently with civil rights litigation. Under federal law, we refer to these as 1983 actions, where a successful plaintiff is entitled to all of their attorney's fees and costs. And
Is this akin to a civil rights action?
I don't think this is. This is saying that, again, I don't need to, I could, as long as I can legally own a gun in this Commonwealth, I can sue, but I don't even need to do that. My college alumni association, which is an out-of-state association, could come in and sue for me because I could legally own a gun here. That is not how 1983 actions work. The ACLU would love something like this where they don't need a named plaintiff anymore to challenge something. So would conservative groups, maybe a group that is upset that there's not prayer to high school. They don't need a kid who anymore wants to pray in high school.
I'd like to touch on that just a real quick second.
And then I want to change the direction just a little bit. But
absolutely.
Finish your thought.
1983 actions, a membership organization can bring a 1983 action, so it does not have to be an individual. Also, when Ms. Goodman was speaking earlier about the fact that the General Assembly had other options available to it, since 1974, it's been a misdemeanor of the first degree for any municipality to enact or enforce any type of firearm regulation or ammunition regulation, and yet that has not dissuaded these municipalities from enacting and enforcing these regulations. In fact, we didn't see the district attorney up in Erie bring charges against the city of Erie when their own ordinance that they sought to enforce was declared illegal and unlawful.
Ms. Goodman.
Because they didn't see it as a problem. Harrisburg is refusing, this is what's happening, Harrisburg is refusing to pass laws to help cities and towns deal with their gun violence problem, keep their people safe, right? But they say they're the only ones who can do it. So some cities and towns have passed some ordinances that they feel are not preempted. What Mr. Prince is now doing is they're taking Act 192, they're using it as a sword and saying, if you don't rescind, even though your thing hasn't been tried in court to see if it's preempted or not, we're going to sue you. And these smaller towns, especially, some of the bigger ones too, they can't risk it. So,
But then let me ask you, because what has happened with Act 192 is you have these various cities repealing their gun laws, but then isn't your beef, so to speak, then with the municipalities, not with the law itself, with Act 192?
No, it's my beef is with the legislature and the gun lobby, because what they have done, what the legislators who voted for this did, was they said the gun lobby is more important than the towns in our district, than the mayors in our district, than the people in our district, and we're going to give a special right that doesn't exist for anything else to the gun lobby to come, and we're going to make it a fee-generating scheme for Josh. So if Josh sues a city and wins, he gets attorney's fees. If Josh sues a city,
this is a job program for attorneys
if
who
Josh
are
loses,
gun lobby. I'm
the
sure
city
you
doesn't
don't
get
see
fees
it that
from
way,
him.
Mr.
Absolutely not. In fact, as you alluded to earlier, we sent out letters to all these municipalities asking them before the law went into effect to simply comply with the law. Again, it was a crime for them to even enact these ordinances. And
So you're saying some of these ordinances are unconstitutional or confusing or not compatible with state law?
Exactly.
Except the court hasn't necessarily held that. Many of these haven't been tested in court and now won't be because of his threatening letters.
But what message are we sending to the youth of Pennsylvania. What we're saying is that our publicly elected officials can't be held responsible for violating the crimes code. That they, in no
Is that what
shape or
this issue is about?
No.
I disagree, because that's the message. CeaseFirePA is telling all these municipalities that either they should enact new regulations regarding firearms or ammunition, or that they should not repeal. To me, that sounds like engaging in a conspiracy to violate the Pennsylvania Crimes Code.
First of all, what we've been telling towns and municipalities is we're supporting what they're doing. They've been put in a terrible position, having to choose between what they believed was right for public safety and their fear for their public budget. We've asked some of them to say, if you can wait to see what happens, because there is a constitutional challenge to Act 192, the way it was passed, wait. But if you can't, we support you. We see that the problem here is the legislators and the gun lobby. And in terms of, the message we're sending to children, if the state was so concerned about these cities, there are ways they could do it. Why should private organizations be given this privilege to take care of what an obligation the state would be?
So if I don't agree with a law that's currently on the books, CeaseFirePA will come out and support me if I believe it's not in the best interest of the public for that law to exist.
I guess it would. Who are you?
Okay,
Though?
and I think we're getting sort of far afield of what our conversation is. You mentioned that there is a a court challenge to Act 192 right now. Where is that headed? What's next, I guess, is what I'm saying here.
So, Pennsylvania Constitution has something called the single subject rule. All parts of a piece of legislation should relate to the same subject. The pieces that we're talking about of Act 192 today, this rights of standing, this right to sue, the right to attorney's fees, were added into a bill that criminalizes the theft of secondary metals. It's about stealing scrap metals from construction sites. How are those two things related? They're not, is the argument, and so therefore it was unconstitutional. Several state senators and representatives and the cities of Philadelphia, Pittsburgh, and Harrisburg have challenged that constitutionally. It's pending in Commonwealth Court. There'll be oral argument in April.
All right. Well, I would love to have you both back after the decision in April to see where we stand with this, because there are still a lot of issues that we need to touch on here. But certainly, thank you so much for taking the time to talk to us about this issue that impacts all of us.
Thank you for having us.
Thanks.